during the break, we submitted to the court the Law&Crime URL for Mr. Jones' press conference that took place outside the courthouse. And what we, first of all, let me inquire, has the court had the opportunity to review that? And I'll also say we intend to submit a copy on a flash drive. And we understand that there's sometimes an issue with URLs and becoming part of the record.
Did you submit it as an exhibit?
We did not submit it as an exhibit, Your Honor, given the time constraints. What we did was provide the URL by email to Attorney Ferraro with a copy, of course, to Attorney Pattis.
Right. So has Attorney Pattis seen it?
Attorney
I
Pattis.
have not.
Okay.
I was just alerted that it was sent.
Is there any reason? Is there anything on it that would be alarming to Attorney Pattis, do you think? I mean, do we need to watch it? We could put it up and watch it.
I just question what the need for this. There's no urgency.
Well, that's what I'm asking, but I think my concern, Attorney Pattis, is I just want to make sure that, because I heard mention of the families, given the nature of the case and counsel, that I just want to make sure that there are no issues. But if
I may have been, I may have assumed more in what I heard than what's there. I thought I heard a suggestion that menacing and/or threatening comments may have been made regarding plaintiffs' counsel and/or their families. As represented to me, they're ridiculing and demeaning remarks, but not threatening remarks, or not remarks of that could lead a reasonable court, in my view, to have the same concerns that's issued as a result of earlier rulings. But that's what I hear.
Your Honor, I would say that we do not have, as a result of Mr. Jones's personal insults towards us and our law firm, think that there are immediate security concerns as a result of that, I would say. So if that was what was prompting some urgency from the court, I don't think that that we need to do that. What we were intending to do now when we came back into court was to inform the court that we've provided the press conference. We will do so as an exhibit so that the court can review it for the purpose of assessing whether, pursuant to its own inherent authority, it should take any action here. And that is what we've come to as what we think the appropriate approach should be.
all right, so I'll take a look at it. Attorney Pattis, is there any reason that you can't attempt to persuade your client not to voluntarily not to interfere with the jurors' oath and obligations if in fact there was any statement that the jurors do independent research despite the court's instructions? Is that something as an officer of the court that you think might not be a bad idea?
Of course not.